the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order.
This may look like a tense exchange between a congressman and a former prosecutor, but it's actually a stress test of the justice system itself. What's really being tested here is whether prosecutorial power is constrained by law or shaped by certainty and discretion. This raises broader questions about how far the government can go when legal interpretation collides with political consequences. In this video, we'll break down how past prosecutions, judicial reversals, and speech restrictions reveal deeper tensions between authority, accountability, and constitutional restraint.
Thank you, Mr. Chairman. Mr. Smith, you've said several times in your deposition that you believe that the facts and the law, your interpretation of the law, would lead to a conviction of President Trump. Is that correct?
Yes.
And did you believe that same thing, that your interpretation of the law, your reading of the law, would have resulted in the conviction when you went after Virginia Governor Bob McDonnell back in 2014? Did you believe it at the time?
I did believe, and
ultimately you got a conviction in lower court, but that was overturned by the Supreme Court, correct?
Yes, the Supreme Court changed the law on what constituted an official act, and
Actually,
as a result, that conviction was overturned.
That's incorrect. They applied the law, and they said in their ruling, our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It's instead with the broader legal implications of the government's boundless interpretation of the federal bribery statute. A more limited interpretation of the term official act leaves ample room for prosecuting corruption while comporting with the text of the statute and the precedent of this court. They accused you of using a boundless interpretation of the federal bribery statute. Now, did you believe when you went after John Edwards that your interpretation of the facts and the law were correct and that you would convict John Edwards of corruption?
Yes.
But in fact, that case resulted in a jury deadlock on 5 charges and acquittal on another charge. Is that correct?
That is my recollection. That's correct.
Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who've yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Both courts upheld the orders, and it is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Did anyone on your team raise concerns that this expansive gag order you were seeking would infringe on President Trump's First Amendment rights?
My recollection is that we, of course, discussed First Amendment issues regarding this application because I and my staff respect the First Amendment, but the First Amendment does not allow one to make statements that interfere with the administration of justice in a judicial proceeding. My interpretation was supported and agreed upon by the district court and the Court of Appeals in terms of the phenomena of the statements being made, targeting individuals, causing threats to happen to them. I would also add, sir, that in the days after Donald Trump made some of these statements, the district court, in this case, received vile threats to the district court's life. In that environment, I felt a duty as a prosecutor to make that motion, and I make no apologies.
And the court stayed that motion on August 3rd, 2024. I yield back.
Gentleman yields back.
What we just witnessed inside that hearing room was not a shouting match or a partisan spectacle. It was something quieter and far more consequential, a sustained interrogation of power, a moment where past prosecutions, Supreme Court reversals, and the boundaries of law were placed side by side and forced into the light. When Mr. Smith was asked whether he believed his interpretation of the law would lead to a conviction of President Trump, his answer was simple: yes. But the follow-up questions pulled the camera backward through time, back to the prosecution of a sitting governor whose conviction did not survive Supreme Court review, back to a high-profile national case that ended not with clarity, but with a divided jury and unresolved charges. In each instance, the same confidence was present, the same belief that the facts and the law pointed in only one direction. And in each instance, the system responded differently than the prosecutor expected. That contrast matters, because it exposes a tension at the heart of American justice, the difference between what a prosecutor believes the law should be and what the law actually is when tested by higher courts and constitutional limits. The Supreme Court did not dispute that wrongdoing can be prosecuted. It warned against interpretations so expansive that they stretch beyond the text itself, against legal theories so broad that they risk turning ordinary political conduct into criminal exposure. And then the focus shifted, from past convictions to present restraints, from courtroom outcomes to the First Amendment itself. The exchange over the gag order cut to the core of American democracy. The question was not whether courts can protect proceedings. The question was whether the federal government should restrain the speech of a leading presidential candidate before any proven harm occurs. Whether the threshold for silencing political speech should be theoretical risk rather than concrete consequence. Mr. Smith defended the request as a duty, a preventive measure, a responsibility to protect witnesses, staff, and the integrity of the court. He cited statements, he cited atmosphere, he cited fear of what could happen if no action was taken. But when pressed, one critical fact remained unchanged. No specific individual was identified as having been deterred from coming forward. No direct causal link was established between speech and obstruction. That silence speaks loudly, because America was founded on the idea that speech is not granted by government permission, especially political speech, especially during an election. Prior restraint has always been treated as the most extreme tool in the legal arsenal, one to be used sparingly and only when absolutely necessary. And that is why this moment matters far beyond the individuals involved. It raises a fundamental question: who decides when speech becomes too dangerous to allow? A prosecutor, a judge, an appeals court, or the people themselves? The courts narrowed the order, they acknowledged limits, they adjusted the scope, and in doing so, they quietly reaffirmed something essential: that even in charged moments, even under pressure, constitutional boundaries still exist. They are not optional. They are not flexible depending on the target. They are the guardrails that prevent power from sliding into something else. This hearing was not about one man. It was about precedent, about whether legal authority expands or contracts when politics enters the room, about whether justice remains blind or whether it begins to look in one direction longer than another. When Mr. Smith said he makes no apologies, it revealed conviction. But conviction alone is not the standard. The American system was deliberately built to distrust certainty, to slow it down, to subject it to review, to force it to answer uncomfortable questions in public. That is what happened here. A reminder that prosecutors do not define the law, courts interpret it, and the Constitution stands above both. Moments like this are easy to miss. There are no dramatic outbursts, no viral sound bites engineered for social media. But these are the moments that shape history, the moments where power is questioned calmly, methodically, and on the record. Because once speech can be restrained without proven harm, once interpretations of law expand without limit, once precedent is ignored in the name of urgency, the system begins to drift, slowly, quietly, and often with good intentions. This hearing was a warning shot, not of chaos, but of consequence. The American experiment survives not because leaders are perfect, but because the structure forces them to defend their choices, forces them to explain, to justify, and to confront the limits of their authority. And that responsibility does not belong to government alone. It belongs to citizens who pay attention, who demand transparency, who refuse to look away when power tests its boundaries. If you believe sunlight still matters, if you believe accountability is not optional, support the work that keeps these moments visible. Subscribe to Liberty Report USA.